Welcome everyone to the first International Mediation Festival organised by the Hellenic Alternate Dispute Resolution Centre on the future of mediation. My name is Catherine Johnson, and like Evie, I too wish to thank the Municipality of Thessaloniki, the Organisation for the Promotion of Alternative Methods of Dispute Resolution, and the World Federation of Consuls for their assistance in this event. I wish to also thank Evie Avloyari and Nikos Karayanakis for honouring me to present this keynote address to this very special event. The Mediation Festival aims to present meaningful dialogue and collaboration that fosters a culture of understanding and harmony. In line with those aims, my keynote address will focus on how aspects of law and psychology combine in mediation to act as an agent for social change that maintains a humane civil society. I use the word humane deliberately and will discuss its significance later in the talk. I claim that the field of dispute resolution is a continuum with psychology at one end and law on the other. And I've called the holistic use of this dispute resolution continuum the Reconstructionist model of mediation. The Reconstructionist model is the interaction of several psychological and legal theories, which together construct not only the micro-social reality of the moment during mediation, but simultaneously construct a coherent macro-social theory for dispute resolution called pragmatism, which I will also describe later. As such, the Reconstructionist model is a social constructionist approach to mediation that uses the whole dispute resolution continuum on a macro and micro scale. My talk will also focus on how the future of mediation unfolds at a grassroots level as the way business is done here, where private agreements between individuals become pragmatic solutions of day-to-day justice, which simultaneously contribute to form new public arrangements in a changing world of social relations. As a psychologist with over 40 years of experience and a barrister mediator with about 30 years concurrently, I realise that there are more significant commonalities between the two professions of psychology and law than there are apparent differences between them. The main similarity is that both psychology and law attempt in their own unique way to address the question of loss arising from shattered expectations. For instance, the loss could be a loss of self-esteem, for which the client seeks the assistance of a psychologist, or a loss resulting from a breach of contractual obligations, for which the assistance of a lawyer is sought. The question proposed in my thesis was, why do people go either to a psychologist or to a lawyer, if not to redress the impact of the grief they feel from some perceived or real loss? The answer to that question culminated in my PhD in law, majoring in dispute resolution, where I make the claim that the very reason for conducting any mediation is the quest for meaning by the parties to make sense of their loss. I further claim that this quest for meaning is the theory behind the practice of any mediation. That is, I claim that a social constructionist approach to mediation highlights the significance of loss and leads to my conclusion that loss fuels the meaning we give to life. As I only have about 45 minutes to cover a very wide topic, I will present my findings and then I'll take any questions if we have time. If not, I've given Evie my phone number and email to pass on to anyone who has a question, which I will happily answer. So, to begin, mediation has often been claimed by notables in the field, such as Lawrence Boole in Australia, as a practice in need of a theory. As a psychologist and barrister interested in therapeutic jurisprudence, I could see that there were many theories being unconsciously used in the mediation process, both from the professions of law and psychology. So my initial attempts in my PhD were to describe how those theories could unite or interact or otherwise contribute to form some major theory of mediation. With further research, however, my attention shifted from just describing the interaction of those theories to recognizing that that interaction itself dealt with the impact of grief from loss on the parties' ability to make decisions, which then further impacted their social relations and the consequent civil society that arose. So the impact of grief from loss on decision-making became the focus of my thesis. As a practicing psychologist and barrister and mediator over the years, I noticed that the long-term effects of grief suffered by my clients from their experiences of loss changed the very fabrics of the relationship in which they lived. This was my first significant point of finding commonality between the two professions of psychology and law. So I attempted to explore how the issue of grief was felt by the parties in my mediations. And I demonstrated as part of my thesis how the 12 stages of Kathy Chamez's work on grounded theory, where we learn from experience, could be used by the parties during the various stages of the mediation process to engage them as researchers, learning about what is meaningful for them from their experience of loss during the mediation process. The aim was for the parties to understand more about how the loss affected each other's respective worldview and how it affected each party's readiness and their willingness to make a decision that could lead to an agreement. I realized that the deeper the grieving felt from the loss, the less likely was the readiness or the willingness of the party to walk a mile in the other's shoes, let alone to settle the dispute. That is, I noticed that grief from loss impacted the meaning we give to events, which in turn had a profound social impact between the parties, affecting not only the quality of their subsequent relationships, but also the quality of the subsequent civil society that arose. And that led me to the work of John Dewey's pragmatism. John Dewey was an American educationalist in the beginning of the 20th century who believed that democracy was best served in small-town America through the cooperation and collaboration of its disparate groups, which together could educate each other about their respective needs and interests to minimize loss in building a series of functional and peaceful communities within the town. Dewey emphasized the importance of education to meet the ever-changing social and economic needs of each of the groups, and believed that their rights were already enshrined in the principles of law, and that their rights formed a stable but malleable boundary in which their ever-changing needs and interests could be met to minimize any loss. Dewey termed this process, where everybody had a say in balancing the needs and interests of the disparate groups within a legal framework, pragmatism, which was in essence an attempt at a dispute prevention process in the development of a democratic civil society. The significance of pragmatism was its emphasis on avoiding obvious and/or potential disputes between the disparate groups and formulating quick and efficient ways to resolve disputes that did occur to keep the town adequately functioning with minimum loss. This highlights the significance of both dispute resolution and dispute prevention in building and maintaining civil society, but also highlights the significant but unspoken role that grief and loss play in developing a civil society. Dewey realized that there was a two-way interaction between the individual and society, where the one made up the other, as if the interaction was an interdisciplinary response between the psychology of the individual's needs and interests on the one hand, and the development of law to administer society on the other. He stressed that there was no such thing as the individual outside of the relations that contributed to the formation of that individual. Relationship then was for Dewey the most important element in any interaction, whether that interaction occurred between people in the environment, or in any other combination. Maintaining healthy and effective relationships was key to the smooth functioning of a civil society, whether that society was in small-town America or in a village in Africa, and minimizing loss to avoid the impact of grief on those relationships was the key unspoken factor. Dewey was such an effective educationalist that he influenced the work of George Kelly, who applied Dewey's principles to the workings of the inner mind to develop his personal construct theory, otherwise termed the individual's worldview. Like Dewey, Kelly emphasized the significance of relations, whether those relations were with the environment and or with people, and stressed, like Dewey, that it is only through our relations that we can apply meaning to the events in our lives as part of our worldview, that is, as part of our personal constructs. The views of John Dewey and George Kelly were a forerunner to the views of Kenneth Gergen, who in his book, Relational Being, defined the way we relate as a game in the making, much like children making up rules as they go for the games that they play. Gergen's account of relational being is best described as the process of being in a world of relations where things are experienced personally, but agreed to collectively to form a higher level of truth, which encapsulates each party's specific experience of truth, much like the 6 blind men describing the elephant in the room from their vantage point. Each blind man is correct in their description, which is their truth, but none is correct in describing the whole elephant. It is only when we share the information that we gain the bigger picture. So too in mediation, when we collectively share the impact of the grief on our respective lives through the exploration of issues, can that grief dissipate and we walk a mile in the other's shoes? Doing so enables the grief to be dissipated so that we can see the world from a higher perspective, which enables us to see the whole elephant. The concept of seeing the world from a higher perspective is best explained by Vargo and Silversberg's mindfulness theory, where a framework for understanding the neurobiological mechanisms of mindfulness is explained through the concepts of self-awareness, through self-regulation, to reach self-transcendence. Vargo and Silversberg claim, like Dewey, Kelly, and Gergen, that we are made up of our transactions with the world, and regulating the experience of loss raises our consciousness to a higher level of self-awareness to reach self-transcendence, where we see the world and ourselves as being united. Being mindful throughout the mediation process opens the path for authentic dialogue, enabling empathy, cooperation, and collaboration between the parties that co-creates greater, richer meaning to our shared experiences. Iselina Ricci also stresses the importance of relations in her 4 stages of relationship chart, which originated from her work on considering the impact of divorce on children. She explains the first stage to be acquaintance or business stage, the second to be friendship, the third is called positive intimacy, and the last stage is termed negative intimacy. These stages, she posits, offer a roadmap for each party to know where along the 4 stages they currently stand, and are a fundamental part of the normative information session, that is, the educational platform in the Reconstructionist model. Ricci claims that whether the transaction is in family law or commercial law, the best stage that allows the parties to move forward from their loss is when they are ready to move from negative intimacy back to business or acquaintance stage. Much easier said than done. She also claims that both parties must have passed through the stages of shock and grief before they can return to the business or acquaintance stage in a constructive frame of mind with which to better handle the loss. Conducting the mediation at a stage where the grief for one party is still high will not only be unsuccessful, but could cause more harm in the thought that the other party may not care about the feelings of the grieving party, or where the grieving party is so overwhelmed that everything is interpreted as deliberately making their life a misery. Vargo and Silversberg's theory and Ricci's theory both stress the significance of relating with the various parts of ourselves and with the various parts of the environment, which makes us who we are. And both accord with Gergen's theory of relational being, as do Dewey and Kelly. Gergen claims that even the most consummate loner is in a relationship with the environment and is therefore intricately connected with it, so that there is no such thing as the individual outside relationship. As stated at the outset of this talk, that is why adequately functioning in a relational world is so important, and why I have used the term relational learning as a significant process in the Reconstructionist model as we learn how to better construct relations with each other that cope with the loss. From Dewey's work, I realized the significance of dispute resolution and/or prevention in minimizing loss to build and maintain a civil society. From Kelly's work, I realized the significance of empathizing with each other's worldview or personal constructs as they constantly make sense of our loss. And from Gergen's work, I realized that the process of mediation itself could similarly be described as the game in the making. That is, as the way of mindfully dealing with the reality of the moment as it constantly unfolds. I realized also that the micro perspectives of theories like the grounded research of Kathy Charmes, where we learn from experience, and the macro perspectives of John Dewey's pragmatism represent a holographic aspect of society, where the micro world of mediation reflects aspects of the macro world of civil society. That is, the social constructionist interpretation of mediation, such as the Reconstructionist model, where it utilizes the whole dispute resolution continuum, could be better understood not just as a micro-settlement process for a specific dispute, but also as part of a macro process where the parties as individuals are better accommodated into a world of relations that are experienced and felt. The focus on the above interdisciplinary theories of law and psychology when engaging the mediation process led me to making the following claims that form the foundational elements of my thesis and present a way for the future of mediation in a globalized digital world. The first claim is that disputes are a common part of everyday life and occur whenever our expectations are shattered, and an attempt is made to redress that loss. In relation to the future of mediation, we note that we live in an ever-changing world of conflict where we attempt to redress or minimize our loss. The second claim is that we attribute meaning to every event of our life, and we do this either consciously or unconsciously. The meaning we give to events arises from our value base or our beliefs, which in turn arise from the shared assumptions we make about how things relate. The third claim is that the impact of grief on decision-making proportionally affects the outcome of the dispute, such that the greater the grief felt, the less likely that a settlement will occur. When considering the future of mediation, collectively acknowledging the effects of grief enables the grief to dissipate and allows the parties to engage in forward movement to resolve the dispute. The fourth claim is that any dispute can be resolved, provided both parties are ready, both parties are willing, and both parties are able, that is, have the skills to do so. The series of exercises offered by the educational platform in the Reconstructionist model called the Normative Information Session enables the parties to determine whether they are ready, whether they are willing, and whether they are able, that is, whether they have the necessary skills to address each issue as it unfolds to the point of resolution. The fifth claim is that the implementation phase of the parties' agreement in mediation, which I've termed observer self, is the process that manifests a public social order from the terms of a private contract. The observer self phase in the Reconstructionist model therefore offers a thorough reality testing of the parts of the agreement, which includes contingency plans if the expected outcomes are not met, with the aim being to construct into manifestation new foundational relations for the parties that better accommodates the loss that must be endured, whether together or apart. My final claim is that an interdisciplinary or social constructionist approach to the future of mediation enables the essential organic nature of our humanness, our humanity, to be fully experienced, arising as it does from the grief felt from the loss. I further claim that this essential nature of humanness cannot be recreated or supplanted by artificial intelligence in our current exponentially advancing digital world, but can only be experienced and felt personally to enhance a cherished life of relations with the world, as well as to enhance a life of cherished, chosen relationships arising from the suffering of grief through the loss. As stated at the outset of this talk, this is how I claim that loss fuels the meaning we give to life. Of these 6 findings, the second finding, that meaning only arises from the shared assumptions about how things relate, forms the crux of the thesis. For example, if we accept that we attribute meaning to every event in our life, then the process of relating is itself a process where the parties attribute meaning based on their agreements about what they believe or assume to be shared meanings or terms of the contract between them. This understanding follows the work of Niemeyer and Sands on bereavement, loss, and suicide, where reconstructing a world of meaning that has been severely challenged by loss is crucial for the parties to move forward after a tragic event. It also accords with the 7 stages of grief by Elizabeth Kubler-Ross in her model for dealing with death and dying, which although a little outdated, still forms an easy scaffold for parties to address their own level of grief. By engaging as grounded researchers, that is, learning what meaning to give to loss and using the normative information session as a framework for asking questions about the reality in which we live, the parties are offered an opportunity in the Reconstructionist model to reconsider and/or change the original meaning given to the impact the loss made on their life to a meaning that can be better endured as they continue to live with the loss. I will not have time to go through the framework of the NIS, the normative information session, or the framework for how the Reconstructionist model unfolds, which could be a topic for another time, but suffice it to say that the normative information session, which is the educational platform in the Reconstructionist model, constitutes the main difference between my Reconstructionist model and every other type of mediation. Traditionally, the problem-solving mediation processes such as the facilitative, evaluative, and settlement models all place their emphasis on settlement and not on the relational aspects between the parties. My claim is that these models therefore need to be rethought and reconceptualized to allow for a social constructionist approach that can inherently deal with the loss through the process of relational learning, where the parties can better accommodate each other's perspectives about their relations to co-construct a new reality together that better deals with their respective losses. I claim that any mediation can be seen to be an organic process when both parties are encouraged to accept that any misunderstanding between them can be clarified when the grief is set aside sufficiently for the same meaning to be accepted by both sides as being the common facts of the case. If, for example, in a personal injury matter, the applicant sees him or herself as the victim of psychological bullying in the workplace, and the insurer claims that the applicant was in fact being the bully, the matter is unlikely to resolve until both parties can accept that there is such a major difference in the interpretation of the facts based on the evidence on the file that a major compromise on both sides is required to reinterpret the facts of the case in a commonly held understanding. If the parties can accept each other's different perspectives and agree to a reinterpreted common set of facts with the necessary compromises, the matter still has good prospects for settlement. But if not, the matter will be determined with all the additional court expenses and with the disappointment on one side as the other side wins. Finding some common ground on which to build consensus, otherwise termed meaning reconstruction, is therefore essential when the facts are greatly in dispute. My claim in the thesis is that meaning reconstruction following loss is an inherent, albeit invisible, unconscious part of any mediation. But a social constructionist interpretation assists the parties to clarify and make the meaning explicit. This makes the resolution of disputes a process for social change. My further claim is that every mediation unconsciously offers parties that same opportunity for social change. But a social constructionist model consciously offers the parties that opportunity, as does each of the professions of psychology and law, as helping professions that assist parties to make sense of loss on a societal and individual level, respectively. For instance, each profession, law and psychology, has a distinct set of protocols and criteria with which to assist the public to resolve or settle their disputes. Psychology deals with the idiosyncratic and unique interpretations of individuals when attempting to fulfill their own needs by making sense of their loss. And law definitively deals with the individual's rights following loss to establish a fair society. As inherently understood, the function of law is to set rules and principles with which to regulate behaviour and determine when we have come into conflict. Law tells us exactly what is lawful and what is not. The function of psychology, however, is to explain the human psyche. Like law, psychological research similarly demands a degree of empirical correspondence between ideas and data to be definitive about the nature of the human psyche. In its pursuit to explain the human psyche, psychological research is necessarily walled off from the messy reality in which we must all live. In practice, however, the clinician faced with the idiosyncratic circumstances and unique demands of a client's situation daily on a case-by-case basis notes that it is not always desirable to be bound by a level of definitiveness that is empirically demanded in an evidence-based approach. The clinician in real-life practice cannot therefore always rely on a broad set of principles that states definitively what to do or say, let alone when to do or say it. So in its attempts to be scientific via an evidence-based approach, the aim of psychological research is to assist psychologists in their daily practice to ask difficult questions when doing their work, so that they can remain skeptical of oversimplified explanations about the human psyche, and can also remain skeptical of reductive answers to complex questions. In this way, psychological research, like legal research, serves as a corrective to maintain our humanness and not to reduce it to a number. By using psychological and legal research as a corrective, clinicians and lawyers can guard against the pervasive human temptation to construct a narrative that matches their own preconceptions, and can also guard against the human temptation to construct a narrative that further matches their unexamined biases in their attempts to cure or to acquit their client. These measures, I claim, offer a social constructionist view of the holistic approach required by both psychologists and lawyers when helping the public to resolve disputes, and offers parties an opportunity as co-creators to create social change. Where then does mediation sit along this dispute resolution continuum in its attempts to resolve disputes? I have made the claim that unlike any other social process, any mediation, including the Reconstructionist model, considers the individual's needs, including their psychological needs, in the context of their legal rights to serve the individual's best long-term interests in a structured format best described as the interplay of the individual in society. As such, the Reconstructionist model, like any mediation, is placed uniquely between the two professions in the extended dispute resolution continuum, something like a marriage between law and psychology, where mediation utilizes the intrinsic elements from both that results in an interplay for mutual social exchange. The Reconstructionist model, unlike other mediation processes, however, attempts to make the parties and the mediator consciously aware of that interplay of processes in which they are simultaneously engaging as relational learners. That is, in the Reconstructionist model, the parties engage consciously as joint researchers grounded in their unique experience of loss, exploring the meanings with which they can best accept their loss and still enable a functional worldview that can at least be tolerated and managed, if not preferred, into the future. In other words, the Reconstructionist model also offers an exercise to the parties via its educational platform of the normative information session presented in the mediator's opening statement to measure their own levels of readiness, willingness, and ability to move forward against the norms as stated earlier. That is, the NIS offers parties a behavioural assignment to reinforce their own relational thinking and engage in responsible action. The Reconstructionist model also offers the mediator the opportunity to similarly become a relational learner with the parties, exploring their unique worldviews as grounded researchers and encouraging the parties to be consciously aware or mindful of their feelings and thoughts in a responsive, not a reactive way, so that each can walk a mile in the other's shoes. Throughout the Reconstructionist model, the mediator also engages as a mirror, reflecting to the parties what they are experiencing at difficult moments in their game in the making, and confirming with the parties if the mediator's interpretation is the intended or desired interpretation. The mediator's role, therefore, is to prepare, to anticipate, to notice reactions of self and parties, to respond, to strategize, and to adapt to whatever is required or whatever unfolds in the game in the making, and by so doing, becoming a constant, mindful, relational learner in teamwork with the parties, ever willing to consider each party's microscopic variations of understanding evident in their interpretation of the terms in which they relate. In other words, the mediator highlights the distortions in understanding of the parties and refers to them as communication problem, which may result from a simple misunderstanding of facts or could be indicative of differences not only in the parties' relational style or transactional analysis state, but more deeply, it could be a difference in their value structure. A difference, in fact, can easily be remedied, such as, for example, when both parties in a job interview agree on a figure of $75 to be paid and find at the time of signing the contract that one party understood $75 per hour, whilst the other understood $75,000 per annum. A difference in relational style, however, is much harder to overcome, as it includes the assumptions forming the values and beliefs of each party, which may not be consciously obvious to the parties themselves. The difference in values is best described by Eric Berne's transactional analysis work, where he claims that human transactions occur in one or more of three ways, that is, through the child, or the feeling creative channel, or the parent, that is, the moral thinking channel, or the adult, that is, the empathy compassion channel, where we experience humour, which Berne claims results in the best form of learning. Berne confirms that the best communication styles occur when the adult of one communicates with the adult or empathy compassion channel of the other, and the worst communication occurs when the parent of one communicates with the child of the other, or the parent of one communicates with the parent of the other, and both take a positional Mexican standoff stance where neither is willing to give way. To this model of Berne, I have added the concept of observer self, where, as previously stated, the best reality testing for the proposed agreement takes place, and where the agreement turns from being a private contract between the parties to an implemented public social arrangement. Time does not permit me to explain further, but I claim that observer self takes the individual from the stage of empathy experienced in Berne's adult to physically manifesting or constructing what that empathy looks like in reality once the parties' agreement unfolds and is implemented. The input from the mediator to explain the forms of relational learning between the parties can therefore empower the parties to recognise that their loss, be it in the form of the family trouble, the emotional disturbance, the bad business deal, is actually brought into meaningful existence by being talked into being in everyday life. In other words, the loss is in fact a construct that has been talked into existence. And as a construct, it can also be changed, that is, talked out of existence. The practical workings of what is constructed and how the construction process unfolds constitutes the game in the making and constitutes the beginnings of an altered worldview with its consequently altered social order. The Reconstructionist model therefore offers parties the opportunity, both jointly and severally, to play a critical role as co-creators of their future in every dispute, and it offers every such mediation an opportunity to change society. In other words, like psychological and research and legal research, The Reconstructionist model offers the parties an opportunity to correct against their own preconceptions and unexamined biases through the assistance of a mediator who is invited, whether voluntarily or otherwise, into the parties' respective messy worlds. Set within a framework of legal rights, parties in mediation can choose jointly and or severally to forego their rights, to pursue what is in their best long-term interests within the parameters of the law, prompting them to change the way they relate to form new functional groups. The Reconstructionist model therefore combines aspects of both psychology and law that work best for the parties under their specific circumstances and can therefore identify the ways of relating that led to the losses and that can also lead them away from the losses. By so doing, the Reconstructionist model can create an opportunity to form new ways of relating to avoid any further loss and to protect the psychological well-being of the parties. As a social constructionist approach, the Reconstructionist model is mindful of the impact of law on the psychological well-being of the parties by encouraging them to be consciously aware of their feelings and thoughts as they constantly weigh their individual needs against their rights to determine how best to make sense of their loss in their best long-term interests. In this way, the Reconstructionist model contributes to the evolution of a fairer society. Hence again, my claim that loss fuels the meaning we give to life. In other words, the Reconstructionist model focuses on the impact the loss has made on the emotional, financial, and psychological well-being of the parties. For instance, the emotional impact associated with loss affects the parties' ability to let go of the original meaning attributed to the loss or to the original terms of the contract. As the emotional impact of the loss varies for each party, it affects their readiness to move forward, which in turn has a direct financial bearing on the outcome of their contract. This is most obvious in personal injury claims where the financial expectations for damages claimed by the applicant are directly linked to their understanding of fairness for the loss of their previous lifestyle. If the grieving for that loss of lifestyle is still very raw, the financial expectations for damages will be very high, with a consequent inability to realistically assess the constraints of the legal process. It is only once the grieving has been reconstructed into a more viable form to honour the loss suffered that the constraints of the legal process can be realistically assessed to gain an outcome that suits the needs of both parties. Under an organic or social constructionist interpretation, such as the Reconstructionist model offers, the conscious and open acknowledgement of the losses of one party by the other, on a substantive and emotional level, creates an opening for the shift of meaning to occur for each party. In other words, acknowledging the existence of the other party's construction of truth or reality without necessarily accepting it creates more willingness to settle or move forward, as principles of right and wrong which are inherent in legislation give way to pragmatism and practicality. Acknowledging the other party's truth removes the need for each party to persist as rigidly to holding on to their own social construct of the truth as if there was no other, and allows an opportunity for the co-creation of new meaning to overcome the emotional and substantial impact of the loss. This is often termed finding common ground to make commercial decisions or cutting your losses as a lesson learned to move forward. To that effect, adopting an organic social constructionist approach, such as the RM, appreciates everyday reality constructing practices and effectively explores the meaning we attribute to the loss, thereby making sense of it. Unlike my presentation of the continuum of dispute resolution that has law at one end and psychology on the other, some studies view mediation and litigation as theoretical constructs which occupy opposing ends of the same procedural continuum of dispute resolution. Without disagreeing with this proposition, I contend that examining dispute resolution from a social constructionist perspective includes the disciplines of psychology as previously mentioned, as well as the nature of mediation at the private end of third-party interventions for dispute resolution. I further contend that examining the continuum of dispute resolution from a social constructionist perspective also calls for a re-examination of certain underlying assumptions regarding the nature of law, as it heads the public end of the dispute resolution continuum. In other words, using a social constructionist approach, law can be seen as the game which aims for fixed rules, as opposed to mediation, which is seen as the game in the making. As mentioned above, law is characterized by procedural fairness, openness, and transparency of proceedings for the sake of natural justice. At the private end of the third-party interventions for dispute resolution, mediation is characterized by flexibility of procedure, confidentiality, and closed proceedings for the sake of privacy, which does not necessarily include natural justice. Law contributes to the principles of justice that comprise the rule of law by which nation-states are publicly governed, whereas mediation contributes to the private arrangements between individuals that allow pragmatic and practical solutions to unfold as concepts of day-to-day justice, which emerge as the way business is done here. This accords with a possible definition for pragmatism as viewed by Dewey to be the way business is done here. From a social constructionist perspective, concepts of day-to-day justice similarly call for a re-examination of the broader practical principles of access to justice within the legal system. Access to justice principles is commonly referred to as third wave reforms, otherwise termed alternative dispute resolution, of which mediation in its various forms comprises the private end of the dispute resolution continuum of third-party interventions. Models of therapeutic jurisprudence, individual case management, such as pre-hearing conferences and court-connected alternate dispute resolution, are all access to justice measures adopted as part of the third wave reforms of the legal system, all of which have varying degrees of public-private exposure, and all of which, like mediation, are examples of non-adversarial justice. A comparison between therapeutic jurisprudence as an alternative dispute resolution measure at the public end of the continuum and mediation as an alternative dispute resolution measure at the private end of the dispute resolution continuum shows that both share a common vision to engage a holistic approach to deal with the impact of law on the psychological well-being of the clients, and both aim to implement a broad framework for appreciating, not critiquing, everyday reality constructing processes. A social constructionist approach to mediation can therefore be seen as an interdisciplinary process that contributes to appreciating everyday reality constructing practices where private arrangements between individuals become pragmatic solutions which unfold as concepts of day-to-day justice and emerge as the way business is done here. By focusing on how aspects of law and psychology combine in the micro practice of mediation and in the macro process of social change, the Reconstructionist model presents the future of mediation as a humane social change process that can be used to promote peace, to present meaningful dialogue, and to offer meaningful collaboration that fosters a culture of understanding and harmony in a globalized relational world. In summary, then, engaging the educational platform of the normative information session in the Reconstructionist model of mediation enables the parties to become conscious of and further engage with the following theories. The first is Kathy Charmez's grounded research theory, where we learn from events grounded in our experience. Kenneth Gergen's game in the making, where there is no such thing as the individual. Iselena Ritchie's 4 stages relational table from her greater study of the impact of divorce on children. Niemeyer and Sand's meaning reconstruction theory. Eric Byrne's transactional analysis theory. Vargo and Silversberg's mindfulness theory. Elizabeth Kubler-Ross's 7-stage theory from her work on grief and loss. John Dewey's pragmatism, where the needs of the disparate group of the towns are understood and accommodated by the townspeople via education, to explain how social changes are institutionalized to change the very fabric of society. George Kelly's personal construct theory, which describes how the individual's disparate needs can be constantly refined through the individual's education to make up their worldview or personal constructs. And lastly, third wave reforms or alternate dispute resolution theories and non-adversarial justice, such as therapeutic jurisprudence. The above theories and researchers all agree that the process of relating is an experiential process that releases our humanness as we overcome the grief felt from the loss experienced. The researchers also agree that the process of relating gives meaning to the events of our life that enables us to live better with the loss. In considering the claim made by Boole and others that mediation is a practice in need of a theory, I claim that a social constructionist approach offers such a theory, as it enables the interaction of various psychological and legal theories discussed herein as processes engaged in mediation to be consciously experienced and felt by the parties on a macro and micro level. That is, the suffering and vulnerability we feel as we grieve releases our humanness to experience meaningful dialogue and collaboration that fosters a culture of understanding and harmony to live a cherished life of relations with the world, as well as the opportunity to live a life of cherished, chosen relationships because of the suffering of grief from loss. As stated at the outset of this talk, this is how I claim that loss fuels the meaning we give to life. Time does not permit me to go any further, but I will provide these notes to further explain what I have presented. For now, let me end by claiming that this presentation aims to bring meaningful dialogue and collaboration that fosters a culture of understanding and harmony to this very first Mediation Festival as it discusses the future of mediation. Thank you.